Hello students, welcome to the English language classes. Today we're gonna talk about the questions asked in the past examination for CA Inter for the chapter of Contract of Pledge, dealing from section 172 till 179. The first question asked in May 2008, state with reasons whether following statements are correct or incorrect. As I always say, such kind of questions you must start your answer with correct or incorrect, then quote the law. No doubt it is of 1 mark. What it says, a pledge of document of title to goods by mercantile agent is a valid pledge. See, pledge again is a bailment, it's a special bailment. There has to be delivery, and the delivery may be of goods or by document of title of goods, and as a mercantile agent under section 178, despite the fact you are not the owner, it's a valid pledge because mercantile agent is defined under section 2 subsection 9 of Sale of Goods Act, which specifically provides he has the authority to raise money on the security of goods. So simply the answer is correct. Second question. Now see, this is a question being asked number of times in May 2008, November 2010, November 2014. It's the same question, just some figures are being changed. So I'll come to this particular part where I'm quoting the answer. See, X sent consignment of goods worth rupees 2,90,000 by railway and got a railway receipt. So when you derive the railway receipt, it is termed as document of title of goods. And as I said in the previous question, the delivery may be by documents, you need not necessarily need the goods. So what you did, you obtained a loan and you pledged goods by the document of title of goods and got an advance of 2,60,000 from the bank and endorsed and delivered the railway receipt in favor of the bank by way of what? Security. So you have given the security of goods but by way of receipt. The railway failed to deliver the goods at the destination. The bank filed a suit against the railway for rupees 2,90,000. Whether the bank would succeed? If you fail to deliver the goods, yes, bank will succeed. See, section 178 says even you can make pledge by deposit of title deeds. That means document of title of goods. So as a pledgee, banker's rights are not only limited to his interest in the goods. His interest is what? 2,60,000. You can sue railways for 2,90,000. This is held in the case of very important case of Morvi Mercantile Bank versus Union of India. Very, very important question. The next question, November 2009, dealing with whether a statement is correct or incorrect. If the pawner, that is pledger, makes a default in the repayment of debt or performance of duty as agreed, the pawnee has a right to sell the thing. Yes, he has the right to sell the things, provided you have to give the reasonable notice, and the question says for which no reasonable notice is given. Sorry, you can't do that. So the answer is incorrect because 176 says you have to give reasonable notice of the sale. Next question, November 2012. What are the essential elements of bailment and the difference between the contract of bailment and contract of pledge? See, going to the essentials, you derive the essentials from section 148. Bailment is delivery. Delivery we do under section 149, transfer of possession. Goods only means movable. And it's for a purpose, and the purpose of bailment may be anything. It may be repair, security, carriage, anything, and you have to return the goods when the purpose is accomplished, right? And there is only transfer of possession, not the ownership. So from section 148 you can derive all these essentials. Going to difference between bailment and pledge. In the normal class, those who have studied from me, obviously I have provided you a code key, so do that. That's a normal thing. And in the difference, I always say 3 points you must pick up. Don't mess with me. That is meaning, example and section. And there is a code key in Hindi. Don't mess with me. PP rose, but what? Badam milk. Like this code key which I have shared with you, right? See, in November 2012 we got the question. In May 2018 we got, but we got with only with regard to what? Differences. So that's a direct question. When you are getting a question of 4 marks, obviously even 5 differences are more than sufficient. So I'm not going into this because it's a direct question. Now going to the next question. That's nice one coming up. Star question. See, this question being asked in June 2009 as well in May 2017. There is a bailiff who pledges his cinema projector and other accessories with a bank for loan. A requests the bank to allow the pledged goods to remain in his possession. See, what we always say, there has to be delivery, which means transfer of possession. Here what the pledger is saying, let the goods be with me and give me the loan and presume it as pledge. Is this going to be a valid pledge? Because for pledge we need the delivery. That's the question. And promises to hold the same interest for the bailiff. That means he says, no doubt you're gonna have the right over these cinema projector. Also further promises to hand over the possession to the bank whenever demanded. Whenever the bank will say, I'll give you back. Now, is this gonna be delivery? So that's the question. Is this gonna be a valid contract or pledge? So here we talked about section 149 dealing with the delivery, which means transfer of possession. Transfer of possession. Now this delivery may be actual or constructive. Constructive means by notice, by intimation, by acknowledgement. Acknowledgement means you are realizing the fact that on these goods they're gonna be right of the pledgee, or we call it as delivery by atonement. So by this particular point, by acknowledgement or constructive, because you are saying that you will hold the goods on the behalf of the pledgee and will hand over the moment they will be demanded. So it is a case of valid pledge. Now November 2019, 2 questions. First part, Shruti acquired valuable diamond at a very low price by voidable contract. So that means what we got? Voidable contract means from whom she has got this diamond, they can get it back. That means voidable contract happens when the consent is not free. No free consent. Because you can avoid the contract under section 19 or 19A. 19A applies when there is a undue influence. The voidable contract was not rescinded, means not cancelled. Now the question is, can she make a pledge over there? Yes, she can make pledge because we do section 178A. Person in possession under voidable contract you can do. There is a case also on this, I can quote. The case of Phillips versus Brooks Limited. Only 2 conditions you have to satisfy. See, pledger has to be in possession of the goods. And pledgee acting in good faith means pledgee is not having any doubt over your title and you must be having the possession. Thus it's a valid pledge. Second part of the question, whether a pony has the right to retain the goods pledged. Obviously pledgee has the right to retain the goods. We do under section 173, not only for the payment of the debt, but you can retain the goods for any interest, any incidental expenses incurred by the pledgee for the preservation of the goods. So you can always have the right to retain. But you may also quote over here section 174, you cannot retain for any other debt. So these are the questions asked. Thank you.